And so that in a nutshell is what the IPC is, and I am currently their treasurer. And so I've really enjoyed working with that group, and so that's a little bit about me. You can see a link to my website bio if you're interested in learning a little bit more. Glenn, let's go ahead and let's advance the slide. So I want to go over a little bit about what are we going to do during this morning's presentation. And first off, I want to talk a little bit about what are trademarks, what functions as a trademarks, and what right does that give a trademark owner. And then also, when you have trademarks, how does that intersect with domain name registrations? What are the rights? What happens when a trademark owner is in a dispute with a domain name registrant? There are different types of ways to resolve those disputes. There is there's traditional litigation, and then there's also alternative dispute resolution, and that would include procedures such as the UDRP, or Universal Dispute Resolution Procedure, whereby a trademark owner can basically ask an arbitrator to award them a domain name, and if certain elements are met, and if the trademark owner is successful, the domain name will be transferred from the registrant to the trademark owner. But it's important to note the UDRP, at least when the decision is first issued, is never final, and a person can always appeal that to a federal court. And if they appeal it, the court gives absolutely no deference to what was done in the UDRP. So you completely start over again. And then we're going to go over just some general steps to take, what you should do as a domain name registrant, what you should do as a trademark owner, etc. We can go ahead and advance it. So what are trademarks? Trademarks are words, taglines, symbols, and logos. There's a few more than that, but those are sort of the big ones. And these are things that associate goods or services with a source. And so when you see certain words, certain taglines, things like that, and you can, recognize those products or those services with a particular source, that's something that's functioning as a trademark. And one of the stories that I always tell, when I go over presentations like this, is that years ago, when I was dating who's now my wife, Liz, we lived in St. Louis at the time, and they had a big balloon festival in St. Louis. And we were in a park with a whole bunch of other people, and there was a family in front of us. And there was a little girl, and I'm guessing she probably was about 3 or 4 years old. And the balloons were up, and they were all over the park. And she looked at one of the balloons and said, "Daddy, it's Pepsi." And sure enough, one of the balloons had the big Pepsi sign on it. It didn't say Pepsi. There was nothing else on it. And so that's sort of a good example of what a trademark is. That symbol, sort of that yin-yang Pepsi logo symbol, is something that people see and that they associate drinks and products with that thing on it as being associated with PepsiCo. And it's also important to note, we'll talk a little bit about trademark registrations, and that's what you can do at different official trademark offices, such as the United States Patent and Trademark Office, or a European Trademark Office, etc. But trademarks exist through use, and you don't necessarily have to register them. And this is particularly true in certain jurisdictions, such as the United States. You actually have common law rights. And so people will sometimes come to me and they'll say, "Hey, I want to get a trademark for X." And I'll say, "Well, tell me about what you're doing." And so, "Well, I've been using this term, been using this logo for the past 10 years to promote my products." And the good news for them is that they don't really need me to, quote, get a trademark. You don't need to hire an attorney. Attorneys don't get you trademarks. Trademarks come about because of just use in commerce. So if you use something to promote goods or services, you have trademark rights, at least as common law. What you can do and what is helpful is you can get what's called a trademark registration, which is whereby you federally register your trademark, and that gives you enhanced rights. And then another thing I think is real important to remember about trademarks is it is very jurisdictionally dependent, which means that if you have trademark rights in the United States, for example, that does not mean that you have any trademark rights at all. And in fact, often you don't in another jurisdiction, such as Canada or Mexico. They have laws that are separate and distinct from the United States, and it doesn't necessarily transfer over. So what rights you have in the US don't transfer to other jurisdictions, and you'll have to comply with, or the trademark owners have to comply with the laws in those particular jurisdictions to have rights. And so keep in mind they are jurisdictionally dependent. The other thing that is interesting about trademarks is that they exist for as long as the mark is used. Registrations do have to be renewed, but again, trademark rights are not necessarily grounded in registrations. Trademark rights are grounded in use. So if you use a mark for 50 years, you're going to have rights for 50 years. And that makes them unique from patents or from copyrights. Patents, for example, have a set term. Typically, it's 20 years from the date of filing. Copyrights have a set term, 100 years from the date of creation, etc. Trademarks are not that way. Trademarks, as long as you use it, you're going to have rights in it. Go ahead and advance the slide. So why do we have trademarks? What's the purpose behind them? And the public policy behind trademarks is grounded in consumer protectionism. We want to make sure that when consumers see a particular mark, that they know the quality of goods and services that they're getting with that particular mark. And I think a good example of that is, think of yourself on a road trip. If you're driving and you're taking a long road trip and you pull up to a stop and you see several different restaurants, and one of them has the McDonald's trademark and one has the Burger King trademark, you're going to know what type of food and what type of service to expect at those different restaurants. You're going to know you're going to get a quote unquote flame broiled burger at Burger King, for example. And so we want consumers to be able to see a mark and be able to know, okay, these are the types of goods and services that I'm going to get with this mark. So if you see the mark Oreo on a package of cookies in the cookie aisle at the grocery store, you're not going to open up those cookies and they're going to be chocolate chip cookies, or they're going to be the chocolate cookies with the cream in the middle. Go ahead and advance the slide. Now, there is a spectrum of marks, and there can be strong trademarks and there can be weak trademarks. And the stronger the mark, generally the more rights you have and the easier enforcement you're going to have. Weaker marks, weaker rights, less of an opportunity to enforce those marks. So what are strong marks? Strong marks are terms, are things that are considered arbitrary or fanciful works or words, actually. And an example of that is Xerox, for copy machines. You can also have, and these are words basically that have no independent meaning by themselves. They're words, they're phrases, and things like that that are just sort of there, and you can't really tell what they are. There's also a term, for famous marks, and those are marks that are so widely used that they've developed a certain, and there's a legal test for this. We won't go over it in this class, but there is a test for it to determine whether or not a mark is quote unquote famous. And if you have a famous mark, you as a trademark owner, you have even further rights. And a good example of that is the Mercedes-Benz mark for automobiles and auto parts, etc. Now, what's on the other end of that spectrum? The other end of that spectrum are weak marks, descriptive marks. So you can have marks that are called generic. And a generic mark is basically a mark that is a term, but it just describes the types of goods and services. So I have here, an example would be restaurant. And so if you open up a restaurant and you call it a restaurant, that's going to be a generic mark. And there's a pretty famous restaurateur here in Phoenix, where I live, that opened up a restaurant, and he called it restaurant. He called it the restaurant. The nice thing about generic marks is that people know immediately what you're selling. But the bad thing about them is that you also don't have very strong trademark rights. Something that is sort of in between a weak mark, a generic mark, and an arbitrary or fanciful mark is what's called a descriptive mark. And descriptive marks are marks that describe a product or a good or a particular good or service. So, for example, a descriptive mark might be something that is geographically descriptive. So, for example, Paris baguette, for those bakeries out there, that's considered to be a descriptive mark because it's geographically descriptive in the fact that it's Paris, meaning that it's located in Paris. Now, we know that Paris baguette is in lots of other locations now, but initially, sort of with that descriptive term, it was seen to be in a descriptive mark. And Glenn, I see you've got a question. You say, Damon, on the food issue, how did it work out for the McDonald brothers and the McDonald Corporation in the 60s? And Glenn, are you kind of asking, is the genus or the issue behind your question, you're kind of wondering how it was that you have two brothers named McDonald and they start a restaurant, and then you have a guy by the name of Ray Kroc who makes the restaurant famous and arguably profitable, and then he now has, in the McDonald brothers, couldn't open up a restaurant called McDonald's, and you're saying yes. That's a very, very good question, Glenn. That is a good question, and I think I don't know if anybody here on the call has seen the movie The Founder about Mr. Kroc. Certainly doesn't portray him in that great of a light. But as a general rule, surnames you can't function. They can't function as a trademark unless you show what's called secondary meaning, and that's exactly what happened in the McDonald's case. And so what happens is you have to go back to what consumer protection, but behind the public policy, which is to protect consumers. So what you have is McDonald's. These two brothers start it, and they open up a restaurant. They call it after themselves, and then Ray Kroc comes along, and he basically makes the restaurant profitable, and he starts building up a franchise system of these different McDonald's restaurants. And so what happens is that consumers start associating the term McDonald's with the source, and the source is really, the franchisor, the McDonald's Corporation. They don't really associate it with the McDonald brothers anymore. And because of that, this descriptive mark, this surname mark, all of a sudden develops secondary meaning because consumers are now associating it with the corporation. And the law would not allow the McDonald brothers to go up and open up a burger joint and call it after their own name. And the reason is they want to protect consumers. And so basically what would happen in that case is you say, well, why would they want to protect consumers in that case? Is because most of the public associated McDonald's with certain goods and services. The burgers and fries that that they serve. And they didn't want to have someone else, even the McDonald brothers or someone else with the last name McDonald's, open up a restaurant called McDonald's and then have them serve just chicken. Because again, I kind of go back to our driving across the country example. So if you're on a road trip or you're driving and you see the name McDonald's for a restaurant, you're going to be able to get cheeseburgers, hamburgers, and a Happy Meal. And so if you went into a restaurant called McDonald's and they served sushi, for example, and it was really expensive, and it was a fancy restaurant, and they had no Happy Meals, and you've got your 3 or 4-year-old kid with you, and your kid was expecting a Happy Meal. You're expecting sort of a certain experience at McDonald's. You could get in, you could get out, you can have an affordable meal, and the kids would be entertained. And all of a sudden, you're in a sushi restaurant that's using the same name. That's not a good position for consumers to be in. They want consumers to be able to see the name McDonald's and be able to recognize, okay, here's what I'm going to get from this restaurant. And that trumps the rights of the McDonald brothers to use their name. So even though, and if you go back and you watch that movie, and if how they portrayed Mr. Kroc is correct, Mr. Kroc is not that nice of a man, but the law still says, you know what, consumers recognize McDonald's with certain goods and services. Therefore, we're going to go ahead and we're going to allow them to go ahead and the company is going to keep the mark itself. And Glenn, you asked another one. So the brothers were doing a physical version of cyber domain name squatting. That I don't know. I think, and I have to go back and kind of look at what happened. And if Glenn, if you know what specifically happened with the McDonald brothers, I think what happened was with them is that they were they were an investor, or they were somehow tied to the McDonald's corporation, and they had a portion of it. And Ray Kroc basically kicked them out for a value that was much less than what their investment was actually worth. I don't know if that doesn't necessarily have to deal with trademark law. It's more of a business law issue, but that's what I believe happened. Glenn, does that answer your question?
Sorry, I was trying to be a little bit funny with my physical version of cyber domain squatting. So if we have two worlds, we have the physical world, like in the McDonald's case, and then there's people who do something quite similar. They change the name slightly in the domain name, and they keep the arches and the imagery and the colors, and so they're sort of not exactly the same in terms of domain space, but they are basically confusing the public in their cyber world.
Correct. Yeah. So it's the same, when we get to cyber squatting, and we'll get to that here in a couple slides, it is basically the same argument, is we don't want consumers to be confused. If you want to go to Nordstrom and you want to buy products and clothes online, we don't want you going to Nordstrom's, plural with an S, and all of a sudden be taken to a company that's going to sell you clothing. It's a lot less expensive, but isn't of the same quality as Nordstrom's, or isn't controlled by Nordstrom's. And so, Bill, I see your comment in the chat, and we'll get to that in just a couple minutes here when we talk about cyber squatting. Glenn, you want to go ahead and advance the slides for me? So let's talk a little bit about domain names. And there are numerous laws, and there are different mechanisms that are set up to protect trademark owners from what are so-called cyber squatters. What is a cyber squatter? Let's talk about what a cyber squatter is, and let's talk about what a cyber squatter isn't. A cyber squatter is an individual who purchases a domain name that is similar to a trademark or identical to a trademark, and basically does it with the intent to hold the domain name and then charge the trademark owner more money to get it, or to somehow interfere with the trademark owner's rights. That's what, and so they're quote unquote squatting on the domain name. So that's what a cyber squatter is. Now, it's important that we remember what is not a cyber squatter. A cyber squatter is not a person who comes along and registers a domain name that maybe it has a trademark of another party. Maybe it has maybe it's a term that's very similar to a trademark, if the intent is to use it for a legitimate purpose. So let's say, for example, that your last name is Kodak. We'll use another name example. And as we all know, Kodak is sort of a famous mark, although it's not used nearly as much anymore. but for film and for pictures. And your last name is Kodak, and you own a landscaping business. And so you go out and you register Kodak.com, and you're promoting your landscaping business. Are you cyber squatting? Absolutely not, because cyber squatting requires you to have an intent to go out there and basically harm and sit on the trademark owner's rights. Merely registering a domain name with a trademark or something that's similar to a trademark when you're not out there definitively trying to harm the trademark owner is not cyber squatting. Now, here are some federal laws. We'll go over a couple here in the United States. One is the Anti-Cyber Squatting Consumer Protection Act in the United States, or ACPA. And another one, which is an alternative dispute resolution option. And by the way, I should talk about an ACPA action requires traditional litigation here in the United States. So if I think that Glenn is registered a domain name, which is similar to my trademark, and I want to assert an ACPA action against him, I have to sue him in court, in federal district court, somewhere in the US. I have to be able to get jurisdiction over Glenn, and the course will proceed in the normal course of litigation. And that's going to be probably a longer procedure, and it's going to be very, very expensive. And I can get relief, and I can get, financial compensation up to $100,000 per domain name. Someone is registered if it's determined to be cyber squatting and if it's willful, etc. But it is traditional litigation. And when I say expensive, I mean, it might cost you $500,000, it might cost you $1 million to take that case to court. And because of the cost and the timeliness of that, there have been different types of what are called alternative dispute resolution options, which are options to resolve disputes outside of litigation that have been set up. And probably the most famous is the UDRP, or Universal Dispute Resolution Procedure. We'll talk about that a little bit further. Glenn, you want to go ahead and you want to advance the slide? So in a UDRP proceeding, here's what, and by the way, these are also elements that are very similar for a cyber squatting action. But in a UDRP proceeding, what does the trademark owner need to show to win one of these proceedings? First off, they have to show that they have valid trademark rights. So let's go back to our restaurant example. If your trademark is for McDonald's and you've got a registered trademark at the United States Patent and Trademark Office, you're probably going to be able to show that you've got valid trademark rights. Alternatively, let's go back to our famous chef here in Phoenix who opened up a restaurant and called it Restaurant. Is he going to be able to show valid trademark rights? Go ahead, just do type your answer in the poll or in the chat, yes or no. Bill says he's typing. Go ahead. If the supposed trademark is restaurant, they're not going to be able to show valid trademark rights. And the reason for that is that restaurant is completely descriptive of the goods and services. So without having, if you have a completely descriptive, actually it's generic. If it's a generic or descriptive term, you're going to have a much more difficult time in establishing trademark rights. And Bill, you say yes and no. For all restaurants, no. For another restaurant in the same city, probably yes. Bill, I agree with that. I think the one thing we want to keep in mind is that trademark rights, they are jurisdictionally based. And so if you have, let's say, for example, a registered trademark, or if you have significant common law rights, it's going to go beyond necessarily the city. So if you've got, the restaurant, McDonald's, for example, that's going to, that's a registered mark. So that's going to cover you pretty much in all 50 states in the US. If you're registered in Canada, if you're represented in the EP, in the EU rather, your trademarks are going to cover you for pretty much all those jurisdictions as well. The other thing that you're going to have to show is that the domain name itself incorporates the mark in its entirety or is confusingly similar. Incorporating the mark in its entirety, those are the easy ones. You take a registered trademark, you just put it in your domain name, and there's nothing else in there. That's a pretty easy case for the trademark owner to show because it's just right there in front of you. However, that's not most cases. Most cases that I deal with, we're dealing with terms that are quote unquote confusingly similar. So if a mark is confusingly similar, it means that it is still likely to cause confusion. It's that the term of the domain name is similar in sight, sound, and connotation and commercial impression, and that there is a likelihood of confusion. So what are some examples? Let's say you misspell a trademark. So you've got Mercedes cars, and instead of ending with an S, if it's mercedes.com, you end it with a Z, or you put two S's on it. You have a typographical error, typos. The law protects the trademark owner, and it says, look, if you've got a mark or if you've got a domain name which is so similar to a trademark, just because of a typo or something else that's still confusingly similar, that's going to meet that element. And the other two elements that the trademark owner needs to show are registered in bad faith and used in bad faith. And these are the hardest ones to show. And if you're accused of cyber squatting, or if you're accused of something like this, these are the areas that you probably could win your case on. Registered in bad faith means that the domain name was registered with the intent to go out there and basically profit from the trademark owner. And in addition to that, you have to have used the mark in bad faith, which means you're using it in a manner which is designed to hurt the trademark owner. Now, the case law has developed over the years to where there's lots of different things that can be considered bad faith. And it can be, for example, you register a domain name that incorporates the trademark, and then you point your website back to the trademark owner's website. That's considered bad faith. If you have a bunch of links on your website for competing goods and services, that's bad faith. And the courts have gone pretty far on this. They even say even if you have a parking page, that can be considered bad faith. And so I know not everybody agrees with that, but that's the current state of the law. Let's go ahead and advance the slide. So this bad faith element, this is what the cases typically turn on. And then, as I said before, registered and used. And this term right now, it's broadly interpreted. Links, holding pages. And then another thing that gets people in trouble is offers to sell the domain name for above registration costs. And this is where I see how a lot of folks get themselves in trouble, is that they'll get a cease and desist letter from a trademark owner, and what they'll do is they'll go back and they'll say, I disagree with you, but I'll sell you the domain name and I'll sell it for $5,000. And you paid $35 to register. You paid $13 to register it. That's going to be bad faith because it's seen as an attempt to profit off of the domain name and charge the trademark owner for it. And so if you're accused of cyber squatting, one of the worst things you can do is to start off and then go back and basically tell the owner, I'll sell it to you for X. Because the courts look at that and they say, you know what? You're more likely a cyber squatter if that's sort of what you're going back with. So that's something we want to be really careful with. Do the next slide. So we talk a little bit about what bad faith is. What is not bad faith? If you have any type of legitimate use of a domain name, so that includes you've got a business, you've got your own personal name that is the same as a trademark, but you're using it for legitimate purposes. So for example, go back to our Kodak example. You want to use Kodak and you have a name of Kodak for landscaping services, something unrelated to film. And you go ahead and you have kodaklandscaping.com and you go to that website and it talks all about, your lawn service, your landscaping service, pictures of, before and after pictures, how to schedule service, etc. that's not going to be considered bad faith because that's use of the mark. That's use of, excuse me, not use of the mark. It is use of the term for legitimate purposes. Another example of what is legitimate use, criticism. So, for example, if you want to use a trademark of another party and you want to have a website that talks about how that other party isn't doing a good job, that's completely legitimate. So, for example, if you want to say Delta Airlines sucks, for example, and you want to criticize Delta Airlines because you think they're late all the time, they lose your bags, and they have bad food and bad customer service, completely legitimate. The law allows for criticism as an example of a legitimate use. And that's important to keep in mind, is that if you're legitimately criticizing a business, you have a right to go ahead and use that domain name. Another example, if you're holding it for a legitimate business or other use, that's good faith. So that's not bad faith. And also keep in mind that it is easier to prove the bad faith element for marks that are strong than that are inherent, that are arbitrary. And the reason is because the law says, well, you've got sort of this funky term. It's funky. It's a registered trademark. So why would you necessarily need to use it? So we'll go back to our example of Xerox. So Xerox, we determined, was a strong mark. It's an arbitrary mark. So if you have Xerox in your domain name, courts are less apt to say, oh, there's probably a legitimate use of that because it's just such a weird term, such an arbitrary term. Versus, for example, our generic example, which is restaurant for restaurants. So, you have, let's say our friend who opened up restaurant and called it restaurant. If he gets ticked off because you've got a domain name that says Restaurant Phoenix, and your site is, and you're going to open up a website that reviews restaurants in Phoenix, that's not going to be, it's going to be a much harder time for the supposed trademark owner and restaurant to show bad faith because restaurant is such a generic mark. And so you see kind of the difference there between the value of a strong and arbitrary mark versus a descriptive or generic mark. Go ahead, Glenn, go ahead and advance the slide. Here's just some other examples of bad faith. Selling the domain name in excess of registration fees, sites with no real purpose. If you're trying to sell competitors' goods, redirecting to the trademark owner site, and also fraud. I've handled a couple cases recently where the website itself had absolutely no content. But what was happening is that these folks were registering domain names with my client's mark in them. The site was completely blank, but they were using email because they had the domain name. They were basically using email addresses associated with the domain name to contact customers. They were basically perpetrating a fraud. And because of that, we were able to show bad faith. Fraud is another one. And again, if you go back to the policy behind trademark law protecting consumers, that's one where it's a bit easier to show that there was, in fact, bad faith, especially if there's fraud. Go ahead and advance the slide. So if you're going about your business and you're worried about a potential claim for cyber squatting, what should you do to protect yourself? What do you do to make sure that you're not all of a sudden you don't register a domain name and it's taken away from you through a frivolous or untoward UDRP action? First off, don't register a whole bunch of domain names you have no use for. If you start registering just a whole bunch of domain names with the idea of just holding them and you're not quite sure which ones you're going to use, if you ever get accused of cyber squatting and one of those domain names is at issue and you can't really point to a legitimate use, the trademark owner is going to have an easier time of showing bad faith. Now, let's say you get that cease and desist letter. What do? I think one of the worst things you could do is not communicate. I think if you've got a legitimate use of the domain name and you get a cease and desist, you want to go back to the sender of the letter and say, look, here's my plan for my domain name, and here's why I plan to use it. If you start to give them facts and things that are concrete as to what your legitimate use is, you're making it much more difficult for them to file a UDRP action. Another thing is that a lot of people, most UDRP actions are won on default judgments. And what that means is that you have a trademark owner, they file the UDRP complaint, and no one else files a response. Well, under the rules of the UDRP, which ICANN approved years ago, is that if you have a complaint and no answer, the panel takes everything in the complaint pretty much as true. And so if that happens and you don't file a response, they're going to look at that complaint, which makes you be out to be the bad guy. And they're going to say, every single thing in here is true. And therefore, we're going to decide it as these are the facts. So if you get a UDRP complaint and you want to object to it, file a response. And I'd recommend you hire an attorney that's experienced with UDRP proceedings to file a response for you. Another thing you want to do is if you've got plans for a business or records, keep those. Keep accurate business plans. So if you're going to build a website around something and you're worried about a potential cyber squatting claim, you're going to need to have a business plan anyway for the website. Write that down, document it. If you're, also document your records. So let's say, for example, you're going to have an e-commerce website, and you're worried about the domain, the URL, the domain name for the website being accused of cyber squatting. Have your business plan for the website. There's more to the website than just there is the domain name by far. Have your business records. You're going to need to have warehouse space. You're going to need to have employees and other things like this for folks to run your website. Document all that. Keep all that. Be prepared to share all that if you're accused of cyber squatting. Advance the slide. Here are things that here's what not to do if you're accused of infringement. Completely ignore the claim, put your head in the sand. That never works because, again, the law is set up to where if only one side participates, if only the complaining party participates, that the panelist in front of that UDRP or alternative dispute resolution, or if it's litigation, the judge is going to take everything they say as being pretty much true because they have to. You don't want to ignore it. Do not demand payment for a domain name if you've registered in good faith. The second you come and you start saying, I'll sell it if you give me money, it looks like cyber squatting, because then the only reason you're seen to have it is you want to get money for that domain name. Another thing I see that doesn't make any sense is a claim of it's mine because I registered it. You may think that, but the law just doesn't support that. There is no law that says there is no first come, first serve for domain name registrations anymore. That went away a long time ago. Be careful of registering domain names that include well-known trademarks unless you really have evidence that your use is legitimate, such as what I mentioned before, business records, etc. Advance the slide. That pretty much brings us to the end of our presentation. Glenn, you have a question in the chat, maybe simplistic question. Is there any form of insurance available to protect your online property? I don't know the specifics of that, Glenn. I do know that there is insurance that will cover claims of trademark infringement, and that's called advertising injury insurance. And whether or not that extends to just domain names or online property, I'm not sure, but I would think that if you were accused, it would probably be a policy by policy type of decision. But if you were accused of infringement, that it might be something that would protect you if the basis of the business is an online business.
Right. Let me tell you a quick story. What happened to me in the 90s. In the mid 90s, I got the rights to distribute a product from South Africa. It was a wind-up radio. It was called Baygen Free Play Radio, and
Okay.
it was a revolutionary product at the time. You would wind it up, and in fact, I have some pictures at the UN where you'd wind it up, and then it would play AM, FM, or shortwave for 20 minutes, and it was developed by this inventor in England, and it ended up being manufactured in Stanton, just a nice area of Cape Town, and they manufactured this radio. But what's interesting is there was a guy in Amsterdam that cyber squatted. He just registered domain name Baygen.com at the time, and the guy was refusing to relinquish it. And this was about 95, and it's really tough. It was a wild west on the internet. And I basically did the soft pedal approach, and I said, look, we're a poor not-for-profit. We can't afford to pay you I think he wanted $100,000 at that time. And so he agreed to take 2 radios. So he gave us the domain name back, but it cost us 2 radios. So which was $100 and something at the time. But it was interesting because some people were making money hand over fist at that time. So I take it over time, the regulations and procedures evolved, but I guess it was a pretty crazy time in the 90s for people who are trying to register their property.
No, you're absolutely right, Glenn, because the internet kind of exploded in the mid to late 90s, and law is slow to catch up. There's 2 reasons for that. One, you're relying on something to go through the court system and to have precedent set, and litigation is slow. The other thing is just legislation is also slow. In order to come up with, so you want to pass a new law, such as the Anti-Cyber Squatting Consumer Protection Act. Well, that takes a lot. And that maybe, especially, when something, even though when it's important, when something is emerging like that, it may not be on the forefront of everybody's mind. And then you see, how slow is legislation these days with things that, people want legislated, want to have legislation on. So that's another issue. And I see Bill has put in the chat, also neither legislators nor lawyers generally have a clue about a lot of new technology. And I think that's, Bill, I think you've got a fair point right there. And I think that speaks to the need for folks like us to work with our legislatures and to educate them. And also, I think that, we should be writing articles and things like that, and we should be explaining what the new technologies are in advance of when they come out. So if we start to hear about particular issues, we need to promote what those issues are on the earlier side of things. And I think one example, it's not a great example because it's already happened once. There's been the 1 round of new GTLDs. And it looks like things that ICANN are moving again for a 2nd round of new GTLDs. That'll be, I think it's maybe 2 years down the pike. I don't know. We'll have to kind of actually when they actually come out. But, these are things people are starting to write about. I think that's a good thing. The more we can publicize these things in advance, the better we'll do.
This has nothing to do with basic IPC stuff, but one of the other legal issues that I think, and it's to do with human rights, is the thing that was really problematic for many years was revenge porn. So poor women were victims of their ex-boyfriends or whatever, releasing, private videos and information about themselves. And they were quite seriously victims again and again and again. It took a long time, I understand, that the legislation came into place to protect these women. Is there usually a huge lag in terms of being proactive? How does that all work?
Well, I mean, it's going to depend upon the jurisdiction. I think, when you're dealing with, there's a huge policy difference there. And I think, like, if you're dealing with, like, trademark rights being violated, the amount of sympathy you're going to get from a legislature is probably going to be, on a scale of a 1 to 10, because, legislatures care about votes. You'll probably be at maybe a 6 or a 7. Folks like trademark owners and things like that are going to be able to pay for lobbyists, which is going to put it in the forefront of a lot of legislatures' mind, and then they're going to have money to donate to campaigns, etc. You'll get an issue such as revenge porn. That is, I think, something that would probably get more attention from a legislative body, just because of the really bad effect in the victims. Individuals, typically these victims are women, and I think that would probably get more attention. And I think there's also another thing with that I think that is helpful is that you probably have privacy laws, and I'm not an expert on this topic at all. But I think with something like revenge porn, you probably also trigger other privacy laws and things that are probably in place that you could use and sort of fit into the internet sphere.
Okay. Since I have you on the line, and it's only a few more minutes, and I hate to do this, but you're coming in as the new chair of NOMCOM. You've had lots of experience. Yeah. And I did not have the pleasure of your company in the past year. It was a lot of work as a NOMCOM member. But is there anything? This is an audience that might be interested in applying for some of the positions that are going to be offered. Is there anything of words of encouragement you can say for people to actually get involved with ICANN on various different constituencies?
Absolutely. Thank you for the opportunity, and don't apologize for bringing it up. I think it's a wonderful opportunity to bring it up, especially to this group. Basically, if you're not familiar, the nominating committee at ICANN appoints 50% of the board of directors. And they also appoint leaders to different groups within ICANN, such as the GNSO, the CCNSO, and the ALAC. And also for what's called the PTI board, or Public Technology Identifiers, which essentially runs the IANA function. It's very, very technical. And so what I would say to this group is that if you have an interest in being involved in ICANN, and you want to know where is a good spot for you to be involved, or maybe if you're interested and you say, I really want to be a GNSO counselor, or I really want to get more involved with the CCNSO or the ALAC, or I want to be a board member, reach out to myself. Or if you know someone else on the NOMCOM, reach out to him or her. And it is our job as the nominating committee, not just to screen resumes and make selections, but we're out there and we're there to promote ICANN. We're there to promote ICANN leadership. And so what I would really encourage folks to do is reach out to your nominating committee, schedule a call. Let's have those conversations and figure out where you're best suited, where your passions are, and let's get those applications in. We don't have a definitive schedule yet for when applications will open and close. We actually have our first meeting with staff in about 5 or 6 hours today. But I would anticipate that time period being probably in the winter months. And so if I invite anybody involved on this call or in this class, you are welcome to contact me. Glenn has my numbers and contact information. I'm happy to schedule a time and to talk to you about leadership roles within ICANN.
Yeah, and one of the things, Damien, that the board really wants to encourage is a more gender balanced and more diverse board as well. That they're encouraging people coming from any location and any background to vet through the process. So it's and I could tell you from the end user community, there's not a lot of applications, and there's a lot of return on investment in terms of your time. Not only what you learn, it's also the people you meet and the opportunities. I cannot speak loud enough. I've been involved with ICANN since 2009 in one capacity or another. And the people I've met over the years, and if you're fortunate enough to get one of the positions within the SOs, the supporting organizations, yeah, you can join the ICANN meetings in person, except for the last 2 years. So all of us have been working with no face-to-face meetings. And normally with the NOMCOM, we meet numerous times face-to-face and do the interviews. And it's been extremely tough doing it all virtual.
But I know. And it is something that time will tell, but I think it's certainly a goal of the incoming leadership team to return to face-to-face meetings this cycle as far as the NOMCOM goes. I don't know what ICANN itself is going to do about a timeline for returning to face-to-face. I think from my discussions with board members, I think that they recognize that ICANN cannot go on indefinitely in a virtual environment. I don't think that's feasible. I think there's a lot of challenges with getting a bunch of people together in the COVID due to the COVID restrictions, but I'm also seeing a whole lot of headway in that. I think, the United States, for example, we're going to open up our borders. Frankly, I think months too late. We're going to open them up next month. It should have been open for months but here we are. And I, for one, am a proponent of allowing people, ICANN volunteers, to pretty much decide for themselves if they want to meet face-to-face. And so I think as soon as restrictions will ease up, I think we ought to start some type of face-to-face meeting again. And it will be difficult. And unfortunately, it's not going to be fair. Because not all governments are going to open up at the same time. I mean, Asia Pac, for example, a lot of the governments in the in Asia are just more restrictive. Australia was very restrictive. China, Japan, Korea, countries like that it's going to be a slower process for a myriad of reasons. But I really see the value of face-to-face meetings, and I certainly will hope those resume. I'm hoping within the year. I don't have any inside information or anything like that, but my personal prediction is that you won't see a quote unquote normal, whatever that means, ICANN face-to-face meeting till 2023. I just think it's going to take a while. There might be some hybrid meetings, there'll be some smaller meetings, but that's just sort of my prediction. What do you think, Glenn?
Well, it's interesting because we're planning our North American School of Internet Governance before the ICANN meeting. I think the ICANN meeting is the 5th to the 8th or 9th. So we're going to do our pre North American School, but we're assuming we're going ahead now. Sure. Pablo Rodriguez, as you know, he runs .PR, and he's pretty bullish, and I think it's going to be a hybrid. Like you said, it could be, sort of geographically only certain countries to be allowed in because of the restrictions by the U.S. CDC regulate what type of vaccines you have. But it seems that they're getting a little bit more flexible on that. But certain countries may be restrictive, but it could be, that you've gotten both your vaccinations, that you had your pre-test. When you get there, you're quarantined for a couple of days, and then there's all kinds of protocols. It's not going to be the normal cocktail parties or your normal meeting. It's going to be a little bit tougher, but I think, I think people are getting tired of just virtual meetings, and this is it's important to get together, and I think we are trying our best with our virtual School of Internet Governance to sort of fill in the void, but it doesn't replace the face-to-face school or the ICANN meetings or the IGFs or the many high variants. We do look forward to the day where we're back to normal again. So absolutely. I agree with that 100%. Great. Thanks everybody. And we had that additional little advertisement to promote NOMCOM at the end. So we should have added at the beginning. This session is brought to you care of ICANN NOMCOM.
Absolutely.
Great. Again, thank you so much, Damien. Pleasure to see you. Thank you, everybody,
Pleasure.
for joining us today. And will be no meeting next week, but please register for the ICANN meeting. We have a ton of meetings all week. So we'll come back at this again, and we'll see you in a couple of weeks. Thank you.
Excellent. Thank you so much, Glenn. Talk to everybody later.
All the best. Bye-bye.